Okay, so I'm going to introduce state dilution law, which goes essentially unmentioned in the text, but is still occasionally important when the plaintiff isn't challenging the defendant's use of a mark the defendant has registered. It's also important when marks aren't nationally famous. Over half the states have dilution statutes. Many, though not all of them, lack a fame requirement. They often, though not always, have some judicial interpretations saying you need some kind of stepped up distinctiveness. But in New York, in theory, the mark allied is protected against dilution. And allied, of course, is probably one of the most standard of laudatory or descriptive terms. Also, most of the states don't define dilution, leaving definition for the courts. So here's an example of a classic state dilution case. The greatest used car show on earth. Ringling Brothers, the registered owner of the greatest show on earth for circuses, successfully sues the car dealership. The state standard in Illinois required distinctiveness plus dilution. In order to find dilution, the Illinois court ruled, it had to find that the mark was deceptively similar, even if the use overall wasn't likely to be confusing. That is, comparing the marks alone, were they deceptively similar? This is a higher standard of similarity than that required to find infringement. Here, the circus-like font increased the similarity to the mark. So the Illinois standard for dilution turns out to be distinctiveness plus deceptive similarity. These kinds of cases are the source of the precedents that the courts in Starbucks and Levi's dismiss as not relevant to the new federal dilution law. If you're the defendant, this is still worth arguing against state law claims, at least. Another key difference, state laws do not have the explicit exceptions found in federal law. The First Amendment may provide some constraints, and many courts will want to interpret state and federal law to be the same, but not every court may do that if the plaintiff is rigorous about it. So let's take a look at another important state law dilution case, Deere versus MTD Products. This is from New York. It is decided under New York state law before there was a federal dilution law. Here are some examples of John Deere's registered marks. And here is the ad at issue. So the Second Circuit found this ad to be unlawful. The alteration in the trademark constituted dilution. It portrayed the trademark in a negative light as boinking amusingly and running from a sweater dog, and not noble and proud like the John Deere wants its deer to be seen. The court also said that it was important that this was an ad by a competitor because it showed predatory intent. And the important point here is that MTD was using the altered mark to refer to John Deere itself. It wanted you to think of and compare it to John Deere. This is not a classic case of tarnishment like Victor's Little Secret, where it's used as a mark for something else. But this raises the very worrisome prospect that a standard comparative ad could also diminish the value of a trademark. So this is another case that triggered litigation. If I can get to it. Nope. We'll see. So Porsche sued Dodge for dilution, claiming that it had a right in the trade dress of the configuration of its car. And one of the things this case highlights is that if the mark is trade dress, showing the product performing badly also shows the trade dress performing badly, which raises particular concerns about the conflict between dilution and competition. The court ultimately agreed with the defendants that no reasonable person would interpret this as making an actual claim about the performance capability of a Porsche versus a fully loaded, Dodge Durango carrying or dragging a trailer behind it. But it's a little worrisome that you should have to do that. The federal exception, by the way, for comparative advertising should cover both Deere and the Passat. Nonetheless, we do have these precedents, especially Deere, saying alteration of a mark can be diluting. And you should consider how far that principle might go if, again, the First Amendment doesn't constrain it. So, for example, here we have a trademark referenced, but not in its original high-class font, which probably decreases the likelihood of confusion, but perhaps walks into a dilution problem, right? So if altering the John Deere mark constitutes dilution, should this also be an alteration that can be diluting? Another question raised by the John Deere case is, okay, did it really matter that it was a competitor? So what about a mockery by a non-competitor under state law? This is from Muppet Treasure Island. And Hormel sued Jim Henson Productions, arguing that Spam would tarnish its mark. So the court says that Spam is actually a likable, positive character, even though he's uncivilized and initially hostile to Kermit. And although Spam and his tribe capture Kermit the Frog and Rizzo and tie them to stakes, causing Rizzo to fear being eaten, the morality of a boar tying a frog and a rat to stakes and eating them is very much an open question. The court took judicial notice of the fact that catch as catch can was the generally accepted rule of behavior in the animal kingdom. So this is funny, but frankly, I find it quite disturbing to suggest that if it had been a negative portrayal of Spam, Hormel could have won its claim against this movie. In addition, the court noted references to Spam in popular culture. For example, in one episode of the television cartoon Duckman, Duckman is shown discovering the secret ingredient to Spam as he looks on to Murray's incontinent camel farm. The Court of Appeals commented that one might think Hormel would welcome the association with a genuine source of pork, or at least a puppet source of pork. In other words, Spam's case was weak because its mark was, in a sense, pre-tarnished. Again, funny, but it's quite disturbing to suggest that if Hormel had had a better reputation, it might have won against this movie. And this is one reason humor is a dangerous game in a judicial opinion. So the Second Circuit said that 3 factors guided it in finding no dilution. First, there was no evidence that there were negative connotations caused by the Muppets. Second, this wasn't an ad by a direct competitor. Third, there was some parody inherent in the defendant's product, which is a movie. It did not tell us what happens if one of those 3 things changes. So some questions about this reasoning that we may discuss in class. Didn't Henson actually have many more choices of characters and character names than MTD did? That is, MTD's biggest competitor was Deere. If it wanted to make a comparative ad, it needed to refer to Deere. Henson had no particular need to refer to Spam. More generally, why doesn't the court say it's a movie? Probably should have done so. That's my view. So this is one reason that the questions at the end of the chapter about Rogers are significant. Should we apply the Rogers rule about artistic uses in non-commercial work to dilution as well? Given the current interpretation of the current exceptions, we don't need it federally, but we might still need Rogers for state dilution, of course, assuming Rogers survives the impending Supreme Court review. So I'll see you in class to talk about that.